Are we ready? Yeah. The Planning Commissioner meeting of February 18th, 2026 will come to order. All rise for the Pledge of Allegiance. Thank you. The Secretary will call roll.
Commissioner Mann,
Oh, here, sorry.
Commissioner Tolson, Commissioner Rice,
Here.
Vice Chairperson Kennedy,
Here.
Chairperson Chrisman.
Here. We're going to proceed to the election of officers. Deputy Director Sean Gibson.
Good evening, Planning Commission, members of the public. This is the time and place set for nomination and election of the Planning Commission Chairperson and Vice Chairperson for 2026. The Simi Valley Municipal Code provides that prior to any vote for the office of Chairperson, the Deputy Director, City Planner, and myself must take all nominations for the office of Chairperson. All nominations must receive a second. Anyone receiving a nomination may vote for themselves. The floor is now open for nominations for the office of Chairperson.
I'd like to nominate Lee Kennedy for chairperson.
I'll second it. We're going to call for the.
Are there any other nominations? Seeing none, is there any discussion you'd like to address?
You want to tell us your platform or?
Yeah, yeah. What is your platform?
My goal is to make every meeting this year. Limit the travel.
You got my vote.
Okay, we have a motion and a second for Lee Kennedy for chairperson. Can we please take a vote? Motion passes unanimously. Tolson abstaining, not abstaining, absent. So chairperson for the Planning Commission for year 2026 is Lee Kennedy. Thank you. Now the floor is now open for nominations for the office of Vice Chairperson. Can I ask for nominations?
Nominate Ken Rice.
I'll second it.
Any discussion?
What is your platform?
My platform is for Lee to make every meeting.
Okay, and the recording secretary will now poll the commission on their vote for office of Vice Chairperson. Okay, the motion passes. John Tolson absent. Congratulations on that. So now is the time for the new chairperson to take his place at the dais, and we will rearrange your nameplates. So it'll be a brief pause here in the meeting.
Sure you don't want to finish up the meeting?
Like musical chairs for adults.
Yes.
Okay, I hope you all read the agenda. Do I have a motion to approve the agenda?
I motion to approve the agenda.
I'll second that.
Okay, motion, I'm new at reading the script. Motion was made by Commissioner Mann and seconded by Commissioner Rice. Unless there are any objections, the agenda stands approved. All right, next step, approval of the minutes. Okay, there's no minutes today? All right. All right, now's the time for the declaration of conflict. The secretary will read the declaration of conflict.
If any member of the Planning Commission may have a conflict of interest or add any reason why that the member must abstain from consideration of any matter on this agenda, he or she should declare this at this time.
Are there any declarations of conflict?
Nope.
All right, seeing none, we'll move on. This is the time allotted for public statements or comments on all the items other than the public hearing items. Is there anyone in the chamber wishing to be heard? Oh, is this where the speaker? James McGillis would like to make a comment. Thank you.
I'm come before you tonight to address the issue coming before you shortly regarding short-term rentals in Simi Valley. On December 15th, 2025, with a motion by Council Member Rocky Rhodes and a quick vote, Simi Valley moved forward to regulate and legalize short-term rentals, or STRs. Last month, the neighborhood councils received 117 pages of material for review. Buried in that packet were municipal code changes redefining and allowing hotels throughout the city. Also, there was a question as to whether the city should ban all short-term rentals. At NC 1, 2, and 3, the executive boards and the public voted to deny the code changes. At NC 3, they also voted to ban STRs. At NC 4, the executive board voted unanimously to ban STRs and to deny the code changes. Subsequently, at the January 26th council meeting, there were no council member comments regarding the overwhelming neighborhood council votes. Even so, Mr. Rhodes got an agreement from the city manager to prepare an amended code package for the Planning Commission. When the amended code package is complete, there will be a 3-day information dump on both the commission and the public. The Planning Commission will have 72 hours to review and make a far-reaching decision in this regard. The code changes redefine any STR as a hotel and would legalize them throughout the city. By voting no to the proposed code changes, the Planning Commission could advocate for a ban on STRs. If so, only a city council vote could override your vote to legalize STRs. 80% of the residents of the residential sales in San Fernando Valley are now to limited liability corporations. If we, the people, do not stop the proposed code changes, dark money and corporate ownership will become the norm in this city. And like me, you may end up with a transient hotel next door to you. Soon, the Planning Commission will be asked to vote against the expressed will of the people. If you support the idea of human beings owning and occupying residences in Simi Valley, it is time for action. You can attend and make public comments at the City Council meeting on Monday, February 23rd at 6:30. As residents, you should demand that each City Council member recognize last month's overwhelming neighborhood council votes. Additionally, if anyone on this dais or any of your immediate household family members has a financial interest in a rental property or a rental property owning company, you must recuse yourself from further discussions and decisions regarding this matter. Thank you very much.
Thank you. Are there any other public statements? I don't have cards for. Okay, we'll move on. Correspondence. Is there any correspondence from the Deputy Director or City Planner at this time?
Chairperson Kennedy, we have no correspondence tonight other than what we have on the agenda.
Thank you. Next on is the consent calendar. Are there any items on the consent calendar?
Yes, Chairperson Kennedy, we have one item on the consent calendar. And it is either recommended that you approve the consent calendar or ask questions or take other action.
Okay, are there any questions on the consent calendar?
I have no questions on the consent calendar.
Commissioner Mann?
No questions?
All right. May I have a motion for approval of the consent calendar? Do we need that by vote?
Move to approve the consent calendar.
I'll second it.
Sorry. Ladies first, of course.
I'm going to second.
You second.
I have a motion and a second. Can we have a vote, please?
This side's better anyways.
All right, we have a unanimous vote with John Tolson not present. Commissioner Tolson? Okay, we move on to continued business. Is there any continued business?
No items. No items, no new business. We'll go straight to new business, item 12.
All right. So, any new business?
Yes, Chairman Kennedy and members of the commission, under item 12B1, we have Planning Commission training tonight. We have city attorney staff here today to kind of do a two-pronged training. Our first portion of the presentation will be by Senior Assistant City Attorney Stephanie Gutierrez on Planning Commission 101. So I'll turn that over to Stephanie, and I think our presentation's up. We could proceed with that.
Thank you. Good evening, Commission. My name is Stephanie. Thank you for the introduction, Deputy Director. So before you tonight, we were asked to just basically go over a really big picture of Planning Commission and everything that maybe the community doesn't realize that goes into consideration while you're up here on the dais. So just to reiterate what we're going through, literally every subject matter that I'm going to touch on may have multiple layers, different cases, different statutory authority. So this is a really high-level review, and I'm happy to take any questions along the way if you have anything to add to it. So we're going to get started by just introducing where planning commissions even come from. I feel like a lot of times the community doesn't even realize that the Planning Commission is basically a local agency's planning agency under the government code. And if City Council didn't choose to create a planning commission, they would actually assume all of the responsibilities that you do on a monthly basis. And so the government code gives City Council the authority to do so, and so you're responsible for guiding land use decisions, ensuring compliance with state and local laws, and then you're also a place where the community can come and engage and be heard on what they feel is sustainable development practice. And this is just, I always like to start with this because this is an example of really what you don't want to see in your city, right? This is kind of the idea of planning in general, to really guide planning and development into different zones that are proper for a certain community, keep residential in residential, commercial in commercial, and maybe prevent something like this where there's a shopping center next to an adult business. So this is exactly what happens when we don't have or don't follow the zoning laws that we have in place. Now, what is the role of Planning Commission as defined in the statutes in Government Code of California? The biggest thing that we have to do here is evaluate development proposals. So Planning Commission is responsible for evaluating those proposals to ensure that they align with community, align with state law and local municipal codes, and even sometimes federal law. And in order to do that, the law dictates that you are what we call a quasi-judicial body, where basically your role is acting as a mini courtroom. Together, you are basically a judge, and you review specific development proposals and apply existing laws to zoning rules, to individual projects. You hold public hearings and consider evidence. And the goal here is to always ensure that the commission understands that we are a fair, unbiased decision maker, and that is the position you're taking when you're reviewing for land use approvals. And I know that we don't really have a problem here in Simi, but oftentimes different communities have an issue distinguishing what a formal public hearing is and then just what public comment on a regular business item is. And so for a formal public hearing, that's what the procedures dictate in state law. So it is literally outlined in the government code, and it is a legally noticed meeting where the public may attend and provide input before a planning decision is made. So whenever you do conduct a public hearing, you'll see on your agendas, you always have that separate space to identify exactly when this special procedure needs to be followed. So the three things we keep in mind are findings. Utmost, we have to basically state the reasons why a project does or does not comply with the zoning code, the general plan, or any other applicable state or federal law before you make the decision. You also have to consider the due process rights that an applicant is afforded during this hearing. So giving the people that are coming before you fair treatment to make sure they receive proper notice of a hearing and a meaningful opportunity to be heard before the Planning Commission makes a decision. And finally, I think the biggest thing that we need to keep, and oftentimes staff is very aware of this when they're conducting your staff reports, when they're writing out everything that you're needing to address during a Planning Commission meeting, is that the idea is these land use decisions can be challenged in court. So everything that we do here, whether it's the written record, audio, video, basically, you have to conduct yourselves in a way where a judge could review these documents and understand what happened and how the Planning Commission reached its decision. That's really the goal of every public hearing that we have. And so to go into that a little further, due process considerations, it is making sure that every person here is fair and impartial, that we're not distracted, right? Whenever an applicant is here, if staff is presenting, if applicant is, arguing for their position on a certain item, that they are meaningfully heard and that they do have a right to a hearing before an unbiased officer. So what is bias? Basically, we have to just make sure that we don't do this, but a bias is when a decision maker has a personal or financial interest in the outcome or has already made up their decision before the hearing, preventing a fair and impartial decision. So that's what we want to avoid. And in adding to that, we also want to make sure that we also disclose any kind of ex parte communications, off-record conversations, and oftentimes that happens when maybe a planning commissioner wants to visit a site, right? You want to get an idea of what the community looks like, maybe what the traffic is at a certain time. Do you agree with the studies that have been presented to you? But again, totally okay. We just have to make sure that the public is aware of that communication and so that we are following the statutory guidelines of a public hearing. And like I mentioned previously, another really large purpose of this is to facilitate community engagement. You are a place to hear public concern about what they want to see, what development that they would like to encourage, maybe issues that they have in their community or in their specific neighborhoods. And so that is a big part of what you do as well. Now, so this is the part of the presentation we're going to really go over very fast, just all the different types of law that you deal with. So just California land use law in general. So some of the key legislations that are often reviewed here as you get items presented to you, CEQA. I'm sure that you've noticed in every staff report, there's a CEQA analysis. It is necessary. Literally, you can have entire courses, college courses on CEQA. We have specialties in CEQA. It is a big, big area of law. And then just planning and zoning law generally, right? It establishes the framework of how planning and zoning regulations are adopted and what should occur in different city municipal codes. And there's also the Subdivision Map Act, which governs the division of land into smaller parcels. And again, these are huge areas of law, but staff does an amazing job of, taking all of that information and condensing it into a staff report that's, easy to review. And in general, even outside of that, just zoning regulations in general, we have zoning districts and classifications. That's outlined in our municipal code. You'll see that referenced. Any kind of permitted uses or conditional uses, that's always addressed in a staff report when applicable as well. And then there's always a method of exceptions to those general rules, right? So variances and zoning amendments, and the code the municipal code outlines the ways that you can kind of go about requesting those amendments. And the biggest thing, the general plan, the largest area, the thing that controls everything, it is the top of the hierarchy whenever anything is considered and brought before you. There's always going to be reference to whether a general plan is complied with. Is the project compliant with the general plan? Do we have, any issues concerning that? And so what does the general plan address? Visions and goals, right? Clear visions for a sustainable community, making sure that the development that we want to see aligns with local needs. Land use elements, again, that in and of itself could be a whole presentation, but land use designations, density, zoning classifications, and then guidance on the kind of development that is associated with each of those classifications. And then it also addresses housing and transportation strategies. And so that's always helpful, just depending on what's being presented before you. Oftentimes you'll see the reference to that as well. And finally, it also provides an implementation framework. It gives you the steps and policies that you need to follow in order to be compliant with what the policies are aligned in the general plan. I'm going a little fast, so I know that this is like, please stop me if you have any questions, but just a little quick intro, like the slightest intro to CEQA, just for anybody who is not aware. We start with an initial study. That's always the first step in the environmental review process, and that really dictates where you go as far as your next step, right? If you find in your initial analysis that there are significant impacts identified, you then move on to an environmental impact report, and really the goal is to, analyze the potential effects of the development and to see if there's any alternatives or mitigation measures that are necessary before following through on that development. And finally, the biggest thing is, really identifying what those mitigations measures are, and then it would be up to the city to monitor and make sure that those are being followed. And so that is just like a general overview of, like I had mentioned, just land use in general, but you also have all of these other things that apply to the Planning Commission just in your role as a commissioner, as a city official for Simi Valley. So you have to consider Brown Act considerations, parliamentary procedure, Public Records Act, conflicts of interest, ethics. All of that is also included in what you do as a planning commissioner. So what's next? I know that was a very large, big picture overview, but really the goal here is to provide information to not only the commission, but, the community. I feel like oftentimes the community doesn't exactly know how you function or maybe why you're making the decisions that you're making. And it could be, just doing a deeper dive into the Housing Accountability Act, why we are limited in our ability to deny or reduce housing, right? A lot of people don't understand that we're not just reviewing projects and putting a rubber stamp on it. There are actual laws we are, limited by. And then findings, right? What is legally required? What constitutes an explanation that a judge would understand how you got from point A to point B, right? Really identifying the statements that explain how the agency applied relevant law to the facts of the project and how that allowed you to reach your decision. And even conditional use permits and conditions of approval, really including that aspect of findings. But there's actual case law that talks about principles of nexus, making sure that the conditions that you are applying are proportional to the effects that that specific development are going to have on the community. And so, like I had mentioned, you have an amazing staff that really goes through all of this analysis and really combines all of it for your review in, your staff reports. But I think the one place that we still have questions, and I feel like you do get a lot of concerns from your community when you do have public comment here, is how do I balance that, right? I'm limited by what state law provides, and I'm hearing that my community has a concern. So how do I show them that we're not just putting a rubber stamp on this project, right? And really, there are two ways. In order for us to approve a project, we use a substantial evidence standard. So really just evidence that is reasonable, credible, and of solid value. And I know that's not, the most solid definition or doesn't provide a huge explanation, but you do that through building a defensible record where, you outline exactly what is required of state law, what is required of our municipal code, what findings are required, what evidence, studies, analysis, case law has been reviewed by staff in order to say, hey, Planning Commission, we actually recommend approval, and these are the reasons why. So again, oftentimes you do have a hard time balancing maybe a project that somebody would not like next door to the fact that we have certain laws that we have to abide by, where if we chose to deny, that denial might not be sustainable in a court. So that is the end of my presentation. My colleague here, Joaquin Vasquez, is going to go over a little more with you with Brown Act and parliamentary procedure, but I don't know, I'm happy to answer any questions on this, or we can kind of circle back after his presentation.
I just want to thank you for the presentation. I thought
Yeah.
that was very well done. And I really appreciate that you used Prezi and not PowerPoint.
Oh, yeah. Something
Speaking of
to
the
maybe
devil.
like not make sure we get your attention here.
I'm still a dinosaur using PowerPoint. I beg your forgiveness. Thank you, Chair Kennedy, Vice Chair Rice. Congratulations. Members of the Planning Commission. I'm here to present on two items very important to what the Planning Commission does. Those are Brown Act training and parliamentary procedure. We're going to hit the Brown Act first and then get into parliamentary procedure second. And the Brown Act is an open meeting law. We have a picture of Ralph M. Brown, who forwarded the bill. It was approved by the legislature in 1953, and just to give some background, leading up to the legislature's adoption of the bill, there was an expose in the Bay Area in the San Francisco Chronicle, 1951, 1952, where a reporter uncovered secret backroom deals made by cities, school districts, county boards. And over these 2 years, he reported on meetings that were sort of window dressing for, kind of checking a public participation box. Public goes away, then they actually make the real decision. So the reporter collaborated with counsel for the counsel at that time for the California League of Cities. They put a draft together, forwarded that to Ralph M. Brown, who was a state legislator from the Modesto area, was known as one that could build coalitions. And this declaration gives the intent, but the idea is the public has a right to know about local state business, and they must be informed on decisions that affect them. And the Brown Act pertains to open meetings. It's set forth in the Government Code. If you want some nighttime reading, you can go to Government Code Section 54950 and explore. But it's really about ensuring the public's right of access. And the key is that all meetings of a legislative body, which we'll get into what that means, of a local agency shall be open and public, and all persons shall be permitted to attend any meeting of a legislative body. What the heck is a legislative body? So this first bucket are ones that are most intuitive to folks: city councils, school boards. This planning commission falls in that second bullet of appointed bodies. You give advisory opinions, advice to the city council, and the third tier, standing committees, which usually relates to city council standing committees. They might have a standing committee on economic development, where you have a couple city council members that have a focused, ongoing subject matter jurisdiction, and their meetings are going to have to comply with the Brown Act. What is a meeting? This is very critical in that the colloquial general conception of a meeting differs from what a meeting is under the Brown Act. So the Brown Act casts a wide net on what constitutes a meeting, which includes a mere discussion, deliberation, hearing, taking action on an item. A lot of times when a body or an individual gets accused of violating the Brown Act, they'll say, well, we didn't make a decision. We didn't come to a final decision on it. That's not the threshold. So it's about getting to that decision, and the key is ensuring that the public has an opportunity to know and participate in that decision. A few different kinds of Brown Act meetings. You're probably most familiar with the first two: regular meetings, special meetings. Emergency meetings, typically more often in the purview of the city council when it comes to pandemics, natural disasters, things of that sort. Adjourned meetings, you might see one of your own regular meetings that could run late into the night, early morning. You might decide to adjourn it to a future time and date. Special meetings can also be adjourned. And these are meeting exceptions. So we have a list that includes individual contacts, conferences. For example, if you go to the League of Cities, the Cal Cities Commission Academy, community meetings, go to meetings of other legislative bodies, the city council, school board meeting. Those would not be a planning commission meeting, of course. Standing committees you can attend. If you're not a member, you can attend as an observer. And social or ceremonial events. If you go to one of your peers' weddings, you're free to attend that. And we'll get into the key of in various scenarios, without memorizing these exceptions, what the takeaway is to keep in mind. And you're going to want to be careful of serial meetings. And there's a time element to this, because in a moment you may think that, well, I'm just having a conversation with one or two people, one or two of my colleagues, or even just one. That could be harmful if things snowball from there. So serial meetings are where you're circumventing the Brown Act essentially through a series of communications to deliberate, discuss, take action on an item without abiding by the Brown Act requirements. There are two main examples. We have the daisy chain example where member A contacts member B contacts member C, and they're discussing business within the jurisdiction of the body. In the hub and spoke example, we have typically a staff member acting as the hub where they contact various members of the body, and they're sharing the impressions from one member of the body to the other. That's the hub and spoke example. And the harm is really done to the public because they don't know that this business in the body's jurisdiction is being discussed. They're not having an opportunity to weigh in and provide evidence or additional basis for your decision making. This is a visual representation of the two serial meeting types. We have the daisy chain, of course, with the straightforward three members of this is a assumed 5-member body where you have a majority discussing, listening to each other, taking action on matters within the body's jurisdiction. And then in the hub and spoke, of course, we have the staff member communicating one-on-one with different members, but sharing information, impressions, essentially facilitating a discussion by a majority of the body. Some individual meetings are okay. You can, of course, engage in separate communications with the person outside of the meeting, public, someone on the body. And it's best to, especially with the public, answer questions, give clarifications, provide information. You might run into a neighbor who says, oh, you know, I saw the agenda, I didn't have a chance to make it. What did the Planning Commission, where did they land on this item? You can, of course, you know, share what the upshot of a decision was. The idea is that you don't want to communicate a member's comments or positions to any other legislative body member conservatively because of course you don't know what that member that you're sharing with might turn around and do. So the best policy, the best takeaway here is if you're going to discuss Planning Commission business, this is a place to do it. Practical tip, before communicating with another commissioner on a matter within the body's subject matter jurisdiction, you can ask that member if they've had any communications with other members. This is really if there's a burning desire that you want to have a conversation about something within the body's jurisdiction. Again, the prudent advice is to avoid substantive discussions on items within your jurisdiction. And even if they say at that time, no, I haven't discussed with anyone else, you don't know what they're going to do tomorrow, and so forth. So practically this plays out in texting, emails, because you never know how those communications can spread. Informal gatherings, use caution when socializing with your peers from the dais. For example, after this meeting, you want to get drinks, get dinner afterwards. You can, of course, do that. All 5 of you could technically do that. It's better if you discuss the Dodgers in spring training or the past Super Bowl, non-sporting events, so long as it's not about Planning Commission, land use, things within your jurisdiction. Again, be cautious with emails. Staff is well-trained in providing you information via email in a way that helps avoid you replying all, inadvertently creating a serial contact or inadvertently having a meeting via email. Be careful on replying, and definitely don't communicate your position on any matter within the jurisdiction, and don't directly reply to a majority. So be cautious when you hit send, whether it's via text, email, social media. If you wouldn't want to see it printed in a newspaper or posted on the internet or in a lawsuit pleading, then probably don't send it. Social media, this is interesting in the sense that the rules for social media do not track your rules for in-person interactions with your peers and the public. So with regard to the public, a majority you can't discuss business with the public, but also with each other. And this includes mere commenting, reposting, liking, responding with emojis. The contrast here is that where in person, technically two of you, if it's limited to two of you, could have a substantive discussion. That's not a majority. That's not a meeting. However, if the same conversation was done on, I still say Twitter, on X, on Facebook, on Instagram, Blue Sky, whatever, that one-on-one interaction that's okay in person is not okay on social media. And my understanding of the legislative intent here is that the nature of social media and how communications can spread very quickly. We hear a lot about going viral and virality. The nature of social media makes it to where the legislature thought that social media restrictions for even one-on-one communications should be limited in this way. So you can answer questions of the public about, when's the next planning commission meeting. I would stick to logistical things like that. But when it comes to substantive issues, again, this is the place to do it. And keep in mind, there is some interplay. This is probably the only thing I'll mention as far as the Public Records Act. But keep in mind that since there was a case out of San Jose, the California Supreme Court has determined that even if you're using your own phone, if it's not a city phone, if you're using your own Gmail, not a Simi Valley email, so long as you're discussing business within your body's jurisdiction, that is disclosable. It's a public record under the Public Records Act, unless some other exemption applies. But it's not uncommon for council members, other members of legislative bodies to have to go through their phones and provide screenshots, et cetera, copies of their emails because they've done business. So it's always best to communicate on city accounts, but also be careful of, what you put in there as well, because they are public records. And this is just a visual contrasting of those two concepts, where above we see kosher for the two council members, in this case, planning commission members, to discuss business in person, but we see that that's not authorized, that even that one-on-one interaction between planning commissioners on social media. Agendas are critical for the Brown Act to allow the public to know what's going to be discussed. Maybe then have to decide between watching Jeopardy or actually coming to give a comment to you all. And so the notice has to have some minimal information of it. It must give the time and date, location of the meeting, and a brief general description of the matters to be discussed or considered. And discussions that stray away from the agenda's description parameters almost always violate the Brown Act. We'll get into few instances where there are flexibility there, but this is the most common one where my colleagues and I have to interject and steer legislative bodies back to what's on the agenda. And definitely appreciate that complex topics that you deal with can often have tentacles and reach into different areas, and intuitively you'll naturally want to discuss things, and there are a lot of connections that you can discuss for a given item, but once you've strayed too far, it's incumbent on your attorney that's sitting with you and on the chair, congratulations again, Chair, to help keep you all on task and focused on the agenda. Timing-wise, the agenda has to be posted for a regular meeting at least 72 hours in advance of the meeting. It's 24 hours in advance for a special meeting. And what happens if there are items that are provided to you, directed to you with regard to an item on your agenda after the agenda has been posted? Very common. Stephanie was mentioning CEQA. So it's not uncommon for 5 minutes before the meeting, you get a 300-page document that says, this is why your CEQA analysis is deficient. Or maybe a little earlier, but if it's after the agenda is posted, there is a requirement that it must be made publicly available. So the best practice, and this is more for staff because it's always pretty certain that you are all going to see it, but it's important, especially for staff, to keep in mind that items directed to you be made publicly available after the agenda is posted. Best practice, put it on the website, give it to the clerk, make it available for public inspection. And again, just driving this point home, you cannot discuss or take action on any item that is not on the agenda. There are some limited exceptions. You can briefly respond to statements, questions from the public. You can ask clarifying questions of staff, even a commenter. You can ask them to clarify their questions because, of course, you want to know what the public is sharing with you. You see this at city councils or planning commissioner comments. You can make brief announcements or reports on personal activities, or often say, hey, you know, here I went to the Commissioner Academy and I did AB 1234 ethics training, tidy things like that. If this is a nice tool, this matter of asking staff to place a matter on a future agenda or request a report back. This is a useful tool in those instances where you might be straying from something that's on the agenda into something that's not. So it's great to say, you know, we definitely want to allow you to talk about this, and we're going to put it on a future agenda so the commission has an opportunity for a robust discussion and so that the public knows you're going to discuss it and has an opportunity to weigh in. There's an emergency safety valve procedure, very, very rare. It does require that action must be taken right now at this meeting. 2/3 of the body has to approve it. And it's not just something that staff forgot about. It has to be something that came to the city's attention after the agenda was posted. Again, very rare. Public participation, bread and butter of the Brown Act, they must be open and public. Comment must be allowed for all agenda items, either during the item or before your consideration of it. A little nuance for special meetings where comment is limited to items on that agenda. So you won't have items on general land use or other planning commission purview items for special meetings. It'll be strictly limited to those listed on the agenda. Time, place, manner limits are legally permissible. The one that is known to most people is a minute limit per speaker when they address the planning commission or the city council. I've seen as little as 1 minute. Typically you see 3 to 5, but the chair can make decisions and has discretion to adjust if you have another client. They had a recent planning commission meeting. Sorry, it was a council meeting, but they had over 300 speakers. So they had to adjust the time downward, of course. And the idea there is in the public interest because you want everyone to have an opportunity to be heard. So as long as the time, place, manner restrictions are not content-based and are even-handedly applied, then they're okay. But I will say public comment, not an opportunity for Q&A. It's more of a one-way street where the public is sharing their impressions, giving their recommendations, or even sharing what really constitutes evidence for you to consider on an item. And it's not your responsibility to respond with questions. You can maybe, in instances, for example, for like a general public comment, you can say, well, Sean, we want that on a future agenda. We want to talk about that on a future agenda. But not an opportunity for Q&A. And I know wanting to connect with the public can be enticing to make public comment an opportunity for Q&A, but that very often when it turns into that risks straying into discussion of items that are not on the agenda. This is supposed to scare you, so don't violate the Brown Act and be guilty of a misdemeanor, please. Most commonly, violations are enforced on the civil side. Practically speaking, there's often, there's required sort of a notice that goes to the agency that says why a member of the public believes that the Brown Act was violated. It's very common for a body, a city that receives that letter to essentially do a redo and ensure that they've dotted their I's and crossed their T's and just redo what they did. But there are serious violations, and it can be very costly if the city is on the losing side, especially when it comes to court costs and attorney fees. Darn those attorneys. But this is just sort of a wrapping up for the Brown Act portion. The Brown Act requires openness, transparency, public access to information, and any gathering that involves the majority of this body, that involves any aspect of decision-making, triggers Brown Act open meeting requirements. Before I pivot to parliamentary procedure, anything on the Brown Act that you had any questions on? Great. So why does parliamentary procedure matter? You're, not wearing powdered wigs. Why do we need all this formality? It is important in the form that applies to you all specifically to ensure orderly meetings, that there's fair and consistent discussion, clear decisions, and effective proceedings. And as far as what governs your commission procedures, so as of the latest version of your commission bylaws, dated 2024, I will say I'm informed that those are due for some revisions. So when those are revised, those will, of course, come to the body. But as it stands now, the bylaws themselves have a section 12 entitled Parliamentary Procedure. And what that section does is it points to the municipal code, and it says that these specific municipal code procedures that apply to the council, they apply to the Planning Commission as well. And of course, we're constrained, limited by state law, including the Brown Act. And if there is a conflict, state law will control. So as part of the council procedures applying to the Planning Commission, the terminology in the code, if you want to take a peek at it, it is those sections. And when you look there, just know that when it refers to council member, it's referring to a commissioner. The council means the commission, the mayor means chairperson, and the city clerk means the secretary. And it's important to note that parliamentary procedure and many jurisdictions either go with an explicit adoption of Robert's Rules of Order. A lot of vintage for Robert's Rules of Order. They're about 1,200 pages, a lot which don't apply to government bodies, let alone cities, let alone planning commissions. And there are more recent, what's called Rosenberg's Rules, which are recommended by the California League of Cities. But what's applied to you in the code is still robust, and we're going to cover the basics to help you understand what you need to conduct a meeting within those rules. So as far as what a quorum does. This is all pretty low hanging fruit to you, but it's essentially the minimum number of commissioners needed to conduct business. So for a 5-member body like the Planning Commission, 3 members need to be present to conduct business. There's no quorum, there's no meeting. As to voting, you need at least a majority of the quorum to take action. So for example, if 3 members are present, you need 2 concurring votes required for action. And Chair Kennedy, this is especially for you. Again, congratulations. Your responsibility is to preside over meetings, state motions or direct them to the secretary to state them. You can't delegate that. You recognize commissioners before speaking. This is especially important, and we see this in courts as well, where you want to avoid people talking over each other, because when there's a record being built for posterity and in building that record, you want to make sure that it's clear. And so the chair directs traffic and says, okay, Commissioner Rice, I'm sorry, Vice Chair Rice, it's your turn to speak on this. What are your thoughts? And providing that order. And that helps maintain order, decorum, and ensuring discussion stays focused and on the agenda item. How do motions work? So motions are how the commission takes action. Procedurally, as you did very well earlier this evening, one member will make a motion, another seconds. The chair states the motion before discussion. And withdrawal, if this is withdrawal of the motion, it is not automatic under the applicable rules after the chair states the motion. So after the motion is stated by the chair, withdrawal can only be made by approval of the mover, who's usually the one that'll get the withdrawal initiated. The seconder also has to approve, as well as a majority of the commission. Voting. So a few different ways to bake a cake here. Votes may occur by voice vote, roll call vote, or the more informal no objection method. Any commissioner under the applicable rules may request a roll call vote. Votes, of course, are entered into the record and are reflected in the minutes. And a tie vote means that no action is taken on an item. So it's always great when we have 5 members all voting. Abstentions. So on that idea of 5 members present, all 5 voting, if you're here, you should vote unless you're disqualified. And disqualification is different from an abstention. For disqualification, for example, if you have a real property interest for property within 500 feet of a project, the state FPPC presumes, those guidelines presume that you have a material conflict of interest and you cannot participate. Doesn't mean you did anything wrong, but there's a song and dance to that, and you cannot participate in the meeting, and a disqualified member no longer counts towards the quorum. For an abstention, I will say, even though you should vote, you may not be forced to vote. No one's going to twist your arm. But an abstention does not prevent commission action. It doesn't handcuff your colleagues, and it does not affect the commission's quorum. Reconsideration. This is essentially voting on prior action that the commission took. It must be made by a person who voted in the majority at the same meeting or at the next meeting, if not stopped. What do we mean by not stopped? I'll get to that after I emphasize why it's important that if you want to do reconsideration, that I strongly advise that you do it at the same meeting. This is because, and it dovetails into the next meeting, if you wait until a subsequent meeting, especially when it comes to land use approvals, commercial business establishment, housing approvals, you will be stopped, the city will be stopped, the commission will be stopped from unringing that bell, because at that point, the applicant developer may have already invested more money in the project. They might have pulled permits. So that makes it more difficult to unwind and legally precarious at that point. So I will say, even though there is leeway in the rules to make the motion at the next meeting, you're likely going to be stopped from doing that at the next meeting. So if you want to reconsider it, I would do it at the same meeting. And for example, as far as who must make it, if a motion passes 3-2, only one of the 3 yes votes may make the motion to reconsider. This makes sense because if you allow people in the minority to continue to make motions for reconsideration, you're going to get stuck on the same items and you're not going to get a lot done. If the motion for reconsideration is adopted, the original motion goes back to the commission for discussion and a new vote. And there is a limit where after one motion for reconsideration, unanimous approval is required for subsequent reconsideration on the same item. I'm going to speak about written findings. Stephanie did a great job earlier in her presentation about talking about the importance, how critical they are. Definitely encourage you to keep that in mind. From my purposes, I'm discussing findings in the context of the rules, the parliamentary rules that apply to you. And so the written findings are reasons that explain your decision. And not all decisions require findings. Of course, when you made a decision to elect Chair Kennedy and Vice Chair Rice, findings were not legally required for that. But if you're approving a CUP, recommending approval of a zoning code amendment, things of that nature, those legally require findings. And this last parent bullet, if rejecting staff's proposed findings, this again comes from the parliamentary rules that apply to you, but a motion must state alternative findings, direct staff to prepare new findings consistent with the decision, or direct staff to reduce oral findings to writing. I will say that, taking a step back from that for the findings to make their way to you from staff, they've been thoroughly vetted by staff, they've been run through legal, but that's not to make you feel like it's a rubber stamping exercise. And you're not required to agree with staff's recommendations, staff's findings. However, your decision must be based, any decision you make in this regard must be based on findings supported by evidence in the record. If evidence in the record doesn't support whatever decision you want to make, it's going to be very legally vulnerable to being overturned by a court subsequently. This is a little recap on sort of the highlights of things that commonly cause confusion. Just wanted to hit some of these again, but motion requires a second. A stated motion cannot be withdrawn automatically. A tie vote results in no action, and reconsideration must be made by a commissioner who voted in the majority. That's my presentation. Happy to answer any questions. Thank you.
I do have a question. If nothing more than to prove I was paying attention, who determines whether an item is stopped from coming back for reconsideration?
So if it's a stopped and time-wise, if there is that gap where it's between an initial meeting and a subsequent meeting, I imagine that for there to be reconsideration, it would have to be on the agenda. There would have to be some discussion with staff. So I think there would be a discussion with staff, the city attorney's office, and even looking at sort of facts based on what the applicant has done to make a determination if estoppel does apply to that motion for reconsideration being considered at a subsequent meeting. So it would go through some vetting in that time.
Okay.
Yeah.
Thank you. Good for me.
Thank you. Very well presented. Thank you. That's on the other?
Yeah, just state we're doing 12B2. Read the title.
Oh, there we go. It's not on mine. 12B2, discussion on reasonable accommodation requests.
Thank you, Chairperson Kennedy, members of the Planning Commission. I want to take a short amount of time today to discuss reasonable accommodation, a brief overview of the process, and we could follow up with some legal comment on that as well. And I have a normal PowerPoint presentation, so I apologize. No, you're fine. So for the purposes of planning, our focus is reasonable accommodation for housing for persons with disabilities. Both the Federal Fair Housing Amendment Act, FHAA, and the California Fair Employment and Housing Act direct local governments to make reasonable accommodations, such as modifications or exceptions in their zoning laws and other land use regulations when such accommodations may be necessary to afford disabled persons an equal opportunity to use and enjoy a dwelling. This could be a zoning regulation such as a zoning setback, lot coverage, animal keeping, or other rule in our code. Over the past couple of years, Planning Commission has seen an increase in reasonable accommodation requests, so we've decided to provide you with a brief overview of the process and some of the guardrails we must follow. Just get my slide correct here. As required by the city's general plan housing element, the city has an existing ordinance that established an application type for requests for reasonable accommodations. Shown here is the Development Code section providing the purpose of reasonable accommodations. This section allows for reasonable accommodations which authorize the director or appointee, which would be myself in this case, to approve requests for persons with disabilities seeking equal access to housing under the acts that result in no fiscal or environmental impacts to the city if implemented in compliance with the provisions, requirements, and standards of the Development Code. A request for a reasonable accommodation may be made by any person with a disability, their representative, or any entity when the application of a zoning law or other land use regulation, policy, or practice acts as a barrier to fair housing opportunities. This, like I said, this may include a modification or exception to the rules, standards or practices for the siting, development, and use of housing or housing-related activities that would eliminate regulatory barriers and provide a person with a disability equal opportunity to housing of their choice. We have an application requirement. It shall be filed in compliance with Chapter 9-30 of the Development Code, and application must be accompanied by information identified by the department. And as I said, the director may grant a reasonable accommodation or may defer the action and the application to the Planning Commission. Generally, the process, as you know, is staff prepares the report currently and it's distributed to the Planning Commission and City Council for a 14-day review, which I'll mention a little later. Much like conditional use permits or other development applications you may see, there are findings consistent with reasonable accommodation law based on these factors, 1, 2, and 3, which is here. Is it necessary to make specific housing available to the individual with disabilities under the acts, be in full compliance with the Development Code and Municipal Code? and be consistent with the purpose, intent, goals, policies, programs, and land use designations of the general plan or any applicable specific plan. Just also to note, reasonable accommodation just doesn't apply to tenant housing or rental housing, but it may apply to your own home or a home that you own. And as discussed, a homeowner or tenant could request a reasonable accommodation request. Similar to some of our other permit types, we may impose conditions of approval such as buffers, environmental protection, landscaping, maintenance, hours, lighting, parking, other performance guarantees deemed necessary and reasonable to ensure that the approval would be in compliance with the findings. We take great steps, just like with any application, to review the surrounding areas and community and potential people that might be impacted. Also, we look at when approving certain reasonable accommodations, one thing we check is there similar allowance that we could relate it to? For example, with ADU laws, you're permitted a 4-foot setback to the side and rear yard. If someone's requesting reasonable accommodation for a accessibility ramp or some sort of special entry, there's kind of a relationship to a similar allowance, which could be a finding for approval. That's very a minor change to the area. With that, we prepare a small report with the findings, potential conditions of approval, and supplemental evidence attached to your report. The director or designee makes an approval. It is subject to appeal. The Planning Commission may choose to appeal the decision rendered by the director. The signatures of at least 2 Planning Commission members is required to initiate an appeal of the decision before the expiration of the appeal period. And just to keep things in perspective, the applicant or someone else may also appeal the request on their own behalf if they don't like the decision or choose to appeal it for other reasons. And of course, the decisions of the Planning Commission are appealable to the City Council. And that initial appeal period of our determination is 14 days. Now, for any legal concerns with the Fair Housing Act and how we process this, I'll turn it over to Stephanie with some general comments as well.
Yes, thank you, Deputy Director. So I just wanted to kind of reiterate in terms of reasonable accommodations. I think the most common thing that we've seen lately is like emotional support animals. But all that to say is these laws actually apply to a large range in considering like our land use designation in our planning department. So I'm just using that as a quick example. So on top of everything that we have to do in terms of the findings that are in the municipal code, there's also federal law that requires us to ask certain questions, including, has the person requesting the accommodation provided information which reasonably supports that an animal does work, performs tasks, provides assistance, or provides therapeutic emotional support with respect to an individual's disability. And that's just federal. On the California side, which is actually more extensive than what is required on the federal level, it is, if you would like to clarify any kind of determination, that clarification from, for example, what we would normally say is like a doctor's note, that note can come from, according to the California Code of Regulations, can be provided by a healthcare provider, therapist, social worker, non-medical service provider, member of a peer support group, parent, child, or other relative. So I'm bringing those things to the attention of the commission to say that, similar to what we had kind of advised earlier in the presentation of each one of these items really has, like 3 different blocks of information or even further that we can really dive into, similar to reasonable accommodations. If, for example, it's for a reasonable accommodation for an emotional support animal, there are multiple levels of different areas of law that staff has to look at. And oftentimes we even get, asked on the legal end, hey, what does this look like? Can we get further clarifications? And there are, federal guidance that is produced, case law that we might have to look at to just see if the situation is similar. So again, just to reiterate the importance of the findings, the evidence that is presented, and really the limitations that are based on state law or federal law that staff, has to abide by.
And thank you, Stephanie. So I think that's a general overview, reasonable combination, unlike, or not unlike, but similar to the other applications you get in your boxes, like administrative action or administrative conditional use permits. Those reviews go through the appeal process or when warranted, the appeal period, and potentially we may see more of these over the coming years because they seem to become more popular, or another avenue, the latest trend, I guess, is an option. So we will continue to take very close looks at those and try to address the zoning rules as closely as possible, staying within the confines of the federal and state laws. But however, if there's any questions tonight, I'm here to try to respond to any of those.
Yeah, what one comes to mind real quick, especially on the emotional support animal side of this, and making these reasonable accommodations. And I know there's all the legal interpretation. I take a lot of fair housing stuff in my business. When the accommodation request is made and it impacts neighbors and other property uses because of that accommodation, at which point does that either get revocable or get take another look at from the legal standpoint of view?
So oftentimes we actually could possibly turn to code enforcement actions. It might just be that we provide some sort of notice of violation and they, I'm just using hens, for example, maybe a noise, it's getting out into neighbors and being disruptive because maybe they didn't isolate the hens in a way that they were supposed to according to the conditions of approval. So it could be as easy as, hey, we received something indicating that there may be an issue. Your conditions of approval with that reasonable accommodation do require that hens are, isolated in the garage or whatever that may look like. We just wanted to follow up and make sure that that was occurring, right? And then we would go through, it is a long process, but we would go through the different avenues of, can we appeal this? Can we withdraw this? What avenues are available? So I think, the point that I always want to bring home here is, again, the idea that commissions or staff just kind of rubber stamp things, that's really not true. Like, we really do try to go through and ask for those clarifications and ask for that, just further information, whatever we need in order to make sure that, yes, you're not affecting the daily life of your neighbor next door as well.
So as a little follow-up to that, what if the staff investigation wasn't complete enough to know that it was a reactive, there was already a notice on that property that created the situation where somebody got into making a reasonable accommodation request? So it was a reactive.
Oh, I see.
See where I'm going with that?
Yeah, and I think that there's only so much that, we can do as far as looking into case law is always something that we kind of just default to because there are those scenarios where a court has identified maybe that issue. And then if that hasn't been identified, we look at different options that, can we understand reasonably, like, for example, that substantial evidence standard, is the information that's being provided credible, right? Is that information only being provided by an angry neighbor that just believes that's what happened? Or is there some sort of proof that that actually did occur, right? But if there are specific questions and if you think that this does require just maybe a little more information or a little more in-depth discussion, I'm happy to come back. We can do a memo to the commission and even another presentation on really different case scenarios that have been vetted. And that way we have an idea of what to look for and maybe be able to address concerns of the community that they have when they see emotional support animals.
Yeah. I think along the lines there was, are we at jeopardy because that information was there and we didn't uncover it prior to the accommodation request? Is that, I mean, that pits maybe one neighbor against another or multiple neighbors against another. At what point does the city come under jeopardy?
So for any kind of reasonable accommodation request, all we can do is review what's in front of us and what's asked for by law. So if we have a certain application process, which is identified in the municipal code, they have to provide us that. If we feel that, for an example, you know, a therapist note didn't really indicate how the nexus of that service animal's presence on the property helps you, we can ask for that further clarification. But even then, federal law doesn't provide, you know, that level of detail that we're looking for. And so oftentimes it is a risk analysis on the city's end. Are we facing a legal challenge? What would that look like? And it might lead to an appeal to city council and or to planning commission first and then to city council. So there are avenues that we can explore, but I think that the specific answers that you're looking for are not so easily attained. Yeah.
Thank you very much. So I was going to go. Anybody else have a comment? Any other commissioners? And thank you for the education. Okay, we're at 13 now. Yep. Oral communication and reports. This item gives the Planning Commission and board members the opportunity to update other members on committees, commissions, or special projects on which they may be participating. Staff? Oh, excuse me,
Staff has no
staff.
comments tonight.
Thank you. Planning commissioners? Excuse me? Planning commissioners? Oh.
I have a comment. I wanted to ask if I can have a pet goat, but it's okay. I already asked you that.
Okay, so we're now at 13C, the Mobile Home Rent Mediation Board.
And Chairman, we have no comments tonight on Mobile Home Mediation Board.
And 13D, Tree Advisory Board.
No Tree Advisory Board comments tonight.
Any other comments from staff or planning commissioners before I close the meeting? This meeting is adjourned.